Hi, everybody. Thank you so much for joining our webinar tonight. We really appreciate you taking time out of your evening to attend. Tonight, we have two partners presenting. Uh, we have Malini Vijay Kumar, and we also have Andrew Montague Reinhold. So they're both partners in our labor and employment groups. So they're going to be going through some questions that are commonly asked around this time and when folks get laid off. So they'll be speaking specifically to folks who have been affected by the Bell layoffs and specific considerations. And my name is Hannah Saunders. I'm the Marketing Communications Manager at Nelligan Law. So this is kind of an open forum Q&A discussion. Our host will start out with a little bit of background information, kind of the basics on severance rights, and then they'll go into the Q&A section. So you should be able to see a Q&A button at the top of your screen. So at any time throughout the presentation, feel free to just click that and answer or ask your questions. And you should be able to toggle to make them anonymous as well if you feel more comfortable doing that. So feel free to ask those and we'll be addressing those throughout the presentation. So I'll pass it over to our hosts and then they can get started.
Great. Thank you guys for coming. So my name is Malini. As Hannah mentioned, Andrew and I are both partners in the Employment and Labor Group. And so we put this together to give you a bit of information as well as answer your questions, of course, given what you're currently going through. So a little bit of a primer on terminations like this. As you may know, your workplace, because you work for a telecommunications company, your workplace is governed by the Canada Labour Code, which is the federal piece of labor rights legislation. And so when you are terminated, these would basically be without cause terminations. If you have any issues with potentially discipline at work, or if anyone has mentioned to you that the termination might have been for cause, then that's certainly a much more nuanced issue and it involves some different considerations. So please get in touch with us if you have questions about that. But for the large, if not entire part of this restructuring, these terminations would be without cause. And so when you are terminated without cause, typically that can happen for almost any reason. There are some prohibited reasons for which you cannot be terminated, such as discrimination, retaliation for exercising your rights under health and safety law, and those kinds of issues. But typically in Canada, in the federal jurisdiction, your employment can be terminated for almost any reason without cause, as long as the employer pays you your entitlements appropriately. So what are those entitlements? There's generally three places that you can look to figure out what your entitlements are when you are terminated. The first place, as I mentioned, is the Canada Labour Code. So this provides your minimum, some call it the floor of entitlements. And there are certain protections here. There is a notice protection or pay in lieu of such notice. So it's a minimum of 2 weeks notice or pay in lieu. And if you've been working at the company for 3 years or more, then it's 1 week for every year that you've worked at the company, up to a maximum of 8 weeks. So basically anywhere in this 2 to 8 week range, the employer has to provide you either prior notice of your termination or pay in lieu of that notice and to continue your benefits, pension, and any other entitlements during that period. Sometimes an employer will do a combination of both. Sometimes they'll do, for example, 4 weeks working notice, 4 weeks pay in lieu, but this has to be provided. And importantly, like I said, your benefits, pension, and other such entitlements have to be continued for this minimum period. And then under the Canada Labour Code, you also get what is called statutory severance pay. And so that's a pretty modest amount. It's the greater of either 2 days of pay for each year you've been with the company or 5 days of pay. So to take an example, let's say you've worked there for 5 years. So your notice entitlement might be 5 weeks. And then your severance entitlement might be 10 days, so 2 days times 5 years. Now, what might be the case for all of you is that your notice entitlements might actually be greater because there is a section under the Canada Labor Code that says that if 50 or more employees are let go within a given period of time, then the employer actually has to provide 16 weeks as minimum notice. So that's double the usual top end of Canada Labor Code notice. And so you might, if you take a look at your termination documents, you might be seeing that perhaps benefits and pension are being continued, for example, for 4 months or something close to that time period. And again, that might be because Bell has followed the group termination rules. So to sum that up, basically, Canada Labor Code, your minimum floor of entitlements. Very importantly, you do not have to sign a release to get what I've just described. The employer has to provide this to you under law, and it cannot ask you to sign any agreement in exchange for that. So you will probably see something in your termination documents talking about, if you do not sign a release, this is what you will receive. And if you do the math, the amount might be 16 weeks plus a certain number of days of pay, and then benefits or pension continuation for around that 16-week period if they're following the group termination rules. Now, that's one kind of source of entitlements. The second place you could look to find out what you might be owed on termination is your employment contract. Now, this is not always a reliable source of information. Your contract might be many years old, depending on how long you've been with the company. There's a chance it might not speak to termination entitlements at all. Or if it does, maybe it says something along the lines of you'll only get your Canada Labor Code minimums. But in some situations, the contract can describe a different notice period. It can't be less than Canada Labor Code, but it might be greater. And so that's something that would be useful to look at as well. But the third source of protections, and this is the most generous source of protections, and also the one that people tend to know the least about, is something called the common law. And common law is what we call the body of judge-made law. So when judges write decisions, those decisions add to what we call the common law. It's judge-made decisions, judge-made law through case decisions. And the common law is often the most generous source of protections for employees. And protection under the common law can amount to, it's a very rough rule of thumb. We measure it based on things like your age, how long you've been with the company, how easy or difficult it might be for you to get a similar job again, how managerial you are, that kind of thing. A general rule of thumb estimate is around 1 month per year of service. And so let's say your employment contract, has some wording in it that talks about what you might get on termination. There are very strict legal standards in the common law for that kind of wording. And if the wording is not specific enough to meet today, 2025's legal standards, then the wording in the contract would be void and it would be replaced by a common law entitlement. And in order to figure out if the wording in your contract is void or not, you would really need to come see an employment lawyer who can review that with the benefit of the knowledge of all of this common law and give you an opinion on that. So 3 different sources of protections. Now, it's important to note that the Canada Labor Code and the common law in particular, they're not in addition to each other. They are part of a whole. So again, I'll give you an example because this type of stuff is a lot easier to understand with examples. Let's take our employee. Let's say we've got somebody who's worked for the company for 10 years. So let's say the company is providing group termination notice. Boom, that's your default of 16 weeks. There's a little bit more in Canada Labor Code severance, about 20 days. Remember that 2 days times 10 years equals 20 days. So 16 weeks plus 20 days, you're looking at something just under 5 months that's been covered under the Canada Labor Code. But let's say this person's contract either doesn't have up-to-date wording, which is very possible if it hasn't been updated in the last 10 years, or maybe just doesn't say anything about termination. Under the common law, it is conceivable that that person might be entitled to something like 10 to 12 months. And again, this is a rough estimate because it depends on the kind of position that person had, how old they are, and those kinds of factors. But let's say they're entitled to around 10 to 12 months. So you got the initial 5 months covered, or almost that covered under the Canada Labor Code. Maybe Bell has offered 7 months total, so that's brought it up a little bit, but there's still that gap there. And that gap is where it can be worth trying to negotiate your entitlements. Now, one very important thing to note about the common law before I kind of pass it off to my partner Andrew for some more general questions is that it's also subject to something we call the duty to mitigate. And so, what that means is if you envision common law severance like a bridge, it's intended to represent the end of one job to the start of the next comparable job. And so if you're able to get off that bridge early, let's say at 4 months, you find, a new job and it's comparable in compensation and stature to what you had with Bell, then that can offset the bridge by a certain amount. And so what this means practically speaking is that your entitlement, your full common law entitlement might be something like 12 months. We will never really be agreeing to a deal with Bell, or I should say, Bell would never agree to a deal that sees them paying that full 12 months free and clear. They'll probably invoke the duty to mitigate. They'll say, look, your client or this employee has a decent chance of finding a similar new job quite soon. So instead of 12 months, we're going to pay, say, 10. And that kind of compromise is very common in these types of negotiations. What we do as employment lawyers is make sure that the employer is not applying too much of a compromise on that amount, and that the overall amount, while it might reflect a bit of compromise on your top end entitlement, is still reasonable. You're not seeing a compromise of like 50%, for example. And so that's where we come in to try and negotiate that for you. But the duty to mitigate is something to keep in mind. And so, although it's very, very fresh early days right now, as you start getting into the job search, sending out resumes, talking to your contacts, you're going to want to keep records of all of these efforts because this will become relevant for severance negotiations down the line. So that's a quick primer on the laws that apply to severance entitlements. There are other nuances. I talked about discrimination and retaliation for health and safety, for example, in the beginning. If any of those factors are present in your situation, then you'll definitely want to flag that for the employment lawyer that you talk to. They might translate to additional damages and entitlements for you. The other thing to keep in mind, too, is that the Canada Labor Code has a protection called unjust dismissal. It applies to people who have at least 1 year of service, who are not what we call true managers. They don't exercise discretion over the strategic direction of the company, for example. And it doesn't apply to folks who have been let go due to a discontinuance of a function of the business, so a true severing of a function of the business. So even if you are in this situation and your title is manager, for example, or you're being told you're let go due to a restructuring, it's worth at least investigating with a lawyer whether the protections of unjust dismissal can apply to you. These are very powerful protections. They can actually, in a lot of cases, folks who are successful with unjust dismissal complaints can even claim their job back. Now, most people don't actually want their job back, but it's powerful leverage to try and improve the package that you've been offered. But because it's such a, or I should say hand in hand with it being such a powerful remedy, the time limit to make such a complaint is very short. You only have 90 days from the date of your termination. So the main takeaway from this is just, you might have received a letter from Bell telling you that you're entitled to certain things and that Bell is going to pay you certain things and that it wants you to sign a release before it pays you those things. Even if you look at your contract and that seems to jive with your contract, even if you think, well, I'm a manager, unjust dismissal might not apply to me, you would be surprised. This is a very complex area of the law, and a lot more people are a lot more protected than they think. So that's why it's good to get a second opinion on what's been offered to you. And the purpose of us offering these sessions too is to try and spread some of that knowledge so that folks at least know that there are questions to be asked about these amounts and these offers. So with that all said as a primer, I'll pass it off to Andrew to give you some more information.
Yeah, and I can just post in the discussion board as well one of our first questions that was sent in. So this one says, if I get a package of 13 months and then I find a job 6 months later, will Bell try and get the money back?
So in terms of whether or not Bell would try and claw it back because you found a new job, I'm going to give a very lawyerly "it depends" answer. So, if you have signed off on the settlement offer from Bell, because whatever they put in the termination is effectively a settlement offer, they're asking you to sign a document that says you will not sue them in exchange for certain money that they're paying you on termination. As long as those documents say you get to keep the money no matter what, you get to keep the money no matter what. Or if they're silent on what happens if you find a new job, you're going to get to keep the money in all likelihood no matter what. However, if you don't sign that back and you did decide to negotiate to try and improve the severance package, let's say you're Molony's hypothetical 10-year employee who maybe is entitled to, 10 months of service, so they reject some lower offer. If all of a sudden at 4 or 5 months that person does find a new job, if Bell finds out about the fact that they found a new job, there is a chance that Bell could decrease its offer or say, okay, we'll just bridge you to your new job, but we're not offering you any more money. So that's when Molony said one of the risks you have to be aware of is your duty to mitigate. That's sort of what we mean. Is if you do push things maybe a little bit too far or further than you need to, and you end up finding a new job, it could affect where Bell's willing to go to resolve things. But again, that's one of the reasons why you really should get advice on things like this is you might get a job offer and aren't sure whether or not you have to accept it or not, and that's one of the ways in which usually lawyers will help you guide you through that process.
Alrighty. The next question that I will post in the discussion as well that we got was, can you quickly explain your fee structure?
Yeah, so the way we do our fees, we actually start with a fixed fee initial retainer. So the first meeting we do with clients now, we do it on a fixed fee, which is 595 plus tax and disbursements, although there's very rarely disbursements for an initial meeting. The idea being we want people to be able to have some kind of certainty as to what it's going to cost them to meet with a lawyer to get an initial opinion on your file. So that's basically we review all your materials in advance. We then meet with you, hear more about your story in case there's something that we you, doesn't come across on the actual documents you send over, and then give you an opinion that's basically yes, the severance package is fair, or no, it's not fair. And if it's not fair, here are some options on how you can improve it and what the cost of doing so is. In terms of what the cost of actually negotiating an improved severance offer is, that really depends on a number of things, including your lawyer. So even at our firm, we have lawyers with various different rates, from more junior people with more lower rates to some very, very experienced lawyers with higher rates. But generally to negotiate an improved severance package, it's in the thousands of dollars. If you ever have to litigate, though, actually sue somebody to improve your severance, it's usually in the tens of thousands of dollars or maybe even more. But again, that's something that you would talk with a lawyer about at every step. Just because you're starting to talk with a lawyer about whether or not you should improve your severance package doesn't mean you're going to the Supreme Court of Canada for tens of thousands of dollars. Like we walk people through every step of the way. There are various times that people can kind of stop walking down that path if the costs are more than they're willing to take. And a lot of that's going to depend on how reasonable the offer is. If Bell made you an offer that's 90 cents on the dollar, odds are the lawyer's going to tell you, you might want to consider just accepting this and not going forward, versus if Bell offers you 10 cents on the dollar, a lawyer's going to say, okay, well, this might be worth your while. So it's really going to depend. But that's roughly how fees work. One other thing about fees, often if we are able to resolve your file, which frankly most employment law disputes resolve before anybody ever has to sue each other because of the costs involved in suing and all of that, more often than not, employers will pay the legal cost. Not always, and we can never guarantee that employers will pay the legal cost as part of a settlement, but it is often part of it. And even if they don't, there are some tax advantageous ways you can deal with the payment of legal fees, including you can use it to as an expense to offset some of your taxable incomes. So just a couple things to think about with legal costs.
Okay, perfect. Thanks, Andrew. The next question we have is, what is the risk in litigating the severance amount? Can I potentially lose the offered amount?
Right. So, so in terms of like, it is very, very rare, not impossible, but rare that if you start negotiating the severance offer that's on the table, that the employer will then take it off the table and not want to negotiate anymore. The way this works is essentially, so Bell will make an offer, it'll have a deadline in it, it'll say, please sign this release and return to us by X date. You have two choices at that point, and hopefully you're able to see a lawyer before X date, or you can get an extension to X date to allow for your meeting with your lawyer. Your lawyer might either say, yep, this is a good offer, you should take it, in which case you sign it, that's done. Or if your lawyer says, I don't know, this is looking like more than, this is looking more like 40 cents on the dollar instead of 90, I think it's worth negotiating if you want to. And once the deadline on Bell's offer comes and goes, that offer is technically expired, which means that it is withdrawn. There is no offer continuing to be on the table from Bell. At that point, you working with your lawyer, you make a counter offer, and then that offer is open for a certain period of time and then expires. So once these offers expire, technically speaking, they're no longer on the table for acceptance. Now, in practical reality, what usually happens is, you send in your counteroffer through a lawyer's demand letter or something like that, and maybe the company says, "Sorry, we're really not in a position to increase the initial amount. The initial offer has expired, but we'll bring it back on the table for one more week." And so, typically, again, we can't guarantee 100% of the time, but the vast majority of the time the employer will do that because they want you to sign that release, that promise that you're not going to sue them or file a complaint about them. That's worth a decent something to them. And so they wouldn't be offering you anything in the first place if your signature wasn't worth some value to them. So they want that signature. They're usually not going to just say, no, forget it. I'm annoyed that you even tried to negotiate. I'm not going to put this back on the table. They usually will bring it back on the table. However, that's not 100% guaranteed, and it is something that you or your lawyer would have to explicitly ask them to do if that was something that you wanted to do. Most of the time, though, what happens is that you make a counteroffer. Bell says, no, that's too much, but we'll increase our initial offer by a bit. You maybe come down by a bit. And at that point, your lawyer, who is quite experienced at doing this kind of thing, will be trying to negotiate and bring Bell up to their highest and best and final offer for you, and then bring that to you and say, okay, here's my opinion on whether this is worth taking or whether the cost and hassle of litigation might be worth it. So that's how that whole process goes. I do see a question as well from one of our attendees, which I'm just gonna speak to real quick. So the question was, what if you don't have your offer letter since it was still on the company PC? So that's, typically not an issue for your consultation meeting with your lawyer. We'll still want to know, like ideally you'd have the initial offer letter or employment contract. If it's possible, you can reach out to HR and say, hi, I've just been let go in the restructuring. I'd like a copy of my offer letter, please. Can you please provide that to me? There's usually no issue with asking for that. But if the company doesn't reply to you, or if for whatever reason, if they just don't provide you a copy of your offer letter, it's still worth meeting with your lawyer. Your lawyer can generally make an educated guess based on how long you've been with the company, how likely it is that your employment contract contains 2025, law standard approved wording. Like if you've been working with a company since 1998 and you haven't signed a new offer letter with a company since then, it's chances are very likely it doesn't meet today's enforceability standards. Chances are high that you are probably a common law employee. We can also sometimes make an educated guess from the amount that is being offered in the termination letter. If the amount looks to be significantly more than your Canada Labor Code minimums and seems to be, maybe just under the low end of the range, but still like some sort of estimate towards common law notice, that's generally a telltale clue that you are a common law employee. So the bottom line is, try and request it from HR, try and see if you can get it before your consultation. It's always more helpful to have it. But if you can't get it, it's generally not a big deal. And the other thing is too, if the company was going to rely on the offer letter to sort of draw bounds around your termination entitlement, usually, but not always, usually they will say that in the termination letter. So yeah, it's still worth going to your meeting.
Just to add on to that too, if Bell thinks that the offer letter or your employment contract helps their position, they're usually, and I don't mean Bell specifically, but any employer, they're usually pretty quick to give it to the employee when asked. If there's delay, if they're kind of like, yeah, we'll get it to you when we get it, it's usually a sign that it probably doesn't limit your entitlements in any meaningful way. Yeah, as Melody said, if they're relying on it, they usually specify it in the termination letter. And just last kind of related point too is courts have said too that employers do have an obligation of acting in good faith, which really means not doing things that make the termination more difficult on the employee than they need to be. Courts recognize that terminations are always going to be difficult, so they're not going to compensate someone for the fact that they've been fired or let go. But if employers are not communicating with the person, not giving the contract, not returning their personal items. If there's ever issues like that, again, those are things to talk to a lawyer about because there are sometimes additional claims that you might have against your employer in that situation.
Oh, perfect. Thanks, guys. So we have another question that is definitely commonly asked in these situations. What happens if you don't accept the terms by the deadline?
So Melanie kind of touched on that a little bit. If you don't accept it by the deadline, it expires. Is really the long and the short of it. But at the end of the day, if 2 or 3 days later you sort of realize, yeah, maybe I want to accept that, you're usually able to get it back on the table because, like Melanie said, they want you to sign the release. That's their sort of assurance that you're not going to sue them. Because one of the deadlines that actually matters is the limitation period, which is generally you have about a 2-year limitation period to sue an organization after you have been terminated, although that can depend on where you're located. So again, get specific advice. But it's generally 2 years. And like Melanie said, the unjust dismissal timeline is 90 days. So if you think that there is something unusual about your termination that actually, maybe I'm part of this big restructuring, but I had just made a harassment complaint and I think they're trying to get rid of me, or I just told them I was going on mat leave, or I've been accommodated because of a disability for the last 2 months and I think they're trying to get rid of me. Those are the types of things that might turn this into an unjust dismissal complaint. And in those situations, you should go get quick advice because that 90 days goes surprisingly quick. And you don't want to be barred from being able to bring a claim like that because it does provide you with a lot of leverage beyond what you'd have of just an ordinary wrongful dismissal claim.
Perfect, thank you. And so we have another live chat question. So it says, to follow up on that last question, can I ask for an extension for the signing of the document for an extended period of time to guarantee that the offer stays on the table while you negotiate with a lawyer?
Yeah, so in terms of the extension, yes, you can ask for an extension of time. More often than not, employers will give the extension of time, and I won't say this is a hard and fast rule, but I do find the more reasonable the employer's being on termination, the more willing they are to provide extensions because the timeline is really to try and put a bit of pressure on people to make a decision by a certain date. Most employers, especially when they've laid off a big group of people, are trying to see how many people will just immediately return the release, and then may try and negotiate or be willing to negotiate with anybody who doesn't. So the deadline is just an artificial deadline that the employer set as sort of this is when we want to hear by anyone before. If you are hiring a lawyer, though, to negotiate an improved offer, one thing to keep in mind is the offer that Bell or whatever employer it was made when you were let go. Um, you're rejecting it. When you have the lawyer send a letter that says, my client is entitled to more money, here's a better settlement offer, that immediately voids the offer that's available on termination. And so technically you can't accept the offer while we're negotiating, because as soon as we make a counteroffer on your behalf, there's nothing that you can accept until Bell counters our counteroffer. However, again, that the point a lawyer is sending a letter, it's because you've had an informed discussion with them about the risks and the benefit of sending the letter. And in your specific situation, you've come to the conclusion based on the advice of, yes, this makes financial sense for me to retain a lawyer to send a letter, and hopefully improve the offer that was made. But yeah, that deadline, if you need more time to think about it, go back to HR and say, I'd like another week. I'm trying to get legal advice. And like I said, more often than not, they are willing to extend that timeline.
And just to sort of add on to that, sometimes what happens is a number of these factors come together at once. So let's say, you've been in negotiations for about 4 to 6 weeks. That's very typical. Especially with large scale terminations like this, the employer can be slow to come back to you. Let's say that you're still in negotiations. Maybe your lawyer made an offer, Bell made a counter offer. There's been some movement, but there's still some distance between the two. And then let's say in the meantime, you're going through an interview process for a new job and it's looking really good. And you get the strong feeling that they might be making you an offer very soon. In that kind of situation, and this does happen, you might come back to your lawyer and say, you know what, I don't care so much about our last counteroffer anymore. Can we just let the employer know that we would accept their last offer, because it gets me out ahead if I account for this new job where I'm quite sure they've hinted that I'm getting an offer and the compensation's really good. So sometimes what we can do, without sort of tipping your hand and saying that disclosing that you have a new job, sometimes we can go to the employer and say, is your offer of X date, can you bring it back on the table? We'd be, I have instructions to convey an acceptance if it's brought back on the table. And so there's a way that we can handle that in kind of a nuanced fashion without making it very obvious that you have new employment. But that's a situation where, you might just want to ask to bring Bell's last number back on the table so you can conclude the matter, freely accept, a new offer with a new employer and move on. So those things do happen. It just takes a bit of practical negotiating.
Perfect, thanks. And we just have another sentence question. Does Bell have to provide a reference letter?
No. Employers don't technically need to provide a reference letter. However, when Melanie has spoken about the duty to mitigate, courts will not look kindly on employers who don't do anything to help the employee try and find a new job if the employer ultimately wants to say the employee didn't do enough to look for a new job, or they should have done more, or whatever it is. So as a matter of course, we often will request reference letters, and some employers are often willing to provide the reference letter. However, they're not technically obligated to do so, but it doesn't help their case because, as Melanie explained, they basically they get a dollar for dollar credit when you find a new job against any liability they have to you. So the fiscally conservative employer should do everything in their power to help you find a new job, because that ultimately lowers their liability to you for anything you're entitled to after you've been let go.
Yeah. And I will say, sometimes folks think that they can't ask their old managers or something like that for a reference letter while they're negotiating. That's absolutely not the case. You can 100% ask, reach out to your old managers if they're still there, or if they're let go, obviously you can reach out to them. But even if they're still at the company, there's nothing preventing you from reaching out just to say, you wouldn't be trying to bring up negotiations with them. That's confidential and that's happening on the legal side of things. But there's nothing wrong with reaching out to them, even while you're in active negotiations, to say, hey, hope all is well with you. would you mind providing me a reference letter? Because the reference letters that are organically written by people who directly know you and managed you are always going to read better and be more helpful to you than, a reference letter that's kind of provided by the HR department that's gone through two sets of lawyers. So you can definitely do that in the meantime if you're job searching while you're negotiating.
Alrighty, and then we have another question from a participant. Have you represented former Bell employees in the past, and what was the general outcome?
Yep, our firm has a long history with representing Bell employees of all levels through basically, I think every wave of restructurings and layoffs and mass terminations that have happened over the last number of years. So yes, we are very familiar with negotiating with Bell. I will say, from all of my experience with Bell, and I think Andrew, I'd love to hear from you as well, but they do negotiate. They are settlement minded. They can sometimes be tough negotiators, but they do negotiate, and they tend to expect that employees are going to at least be going and seeking counsel on their severance packages. So yeah, but we have concluded many a deal with Bell in the past.
Yeah, I've represented a ton of Bell employees over my career,
Yeah.
both in these sort of mass termination situations, because as I'm sure you're aware, there's a history with Bell, especially over the last 10 years. Well, not just Bell, Rogers, all the kind of big
Yeah.
Canadian telecoms and whatnot. But yeah, in sort of mass terminations, in individual unjust dismissals, in workplace harassment, like harassment type situations. Um, yeah, our firm is very experienced working with Bell employees, and yeah, the general outcome, anything that's been resolved would have confidentiality provisions attached to it. Not to mention it would be a solicitor client, but I can say that we have. I think provided value to any Bell employees we've ever met with, even the ones that don't retain us, because sometimes the advice is we get the severance offer and somebody might be made an offer even in the hundreds of thousands of dollars, and our view is, yeah, that's reasonable. And at least what people like that often find is they're not kind of kicking themselves down the road wondering whether or not they could have done better or not. They sort of have that satisfaction of, look, okay, if I'm going to sign this document, at least I know it's fair and I can kind of sleep easy at night. Sometimes I sort of describe it as the equivalent of like a home inspection before you buy a house. Because yeah, it could be a six-figure amount of money that you're not sure whether or not you should be signing the contract about or not. You might as well have somebody look under the foundation and make sure there's no cracks. And I almost feel apologetic when I'm in a meeting with a client and I'm telling them, yeah, there's nothing we can do. But actually, that's the best answer you should get, because that means that the employer is at least treating you fairly on termination. It means you can sign the document back, and it means you can kind of move on with your working life. Where sadly, if you are retaining us, it's because you're not being treated fairly usually, and it's you'd rather be the person that we say, sorry, there's nothing we can do for you, because it means you can move on a little bit better and more quickly.
Yeah.
Perfect. Okay, so unless anyone in the participating has any more questions, I'll just kind of start wrapping it up and speak to a few logistics as well. So thanks again for attending, and we really appreciate you taking out of your time in the evening to come to this session. So for everybody who has registered, I'll be sending an email tomorrow morning with a recording of this webinar in case you want to review any information, as well as contact info for our hosts, and also an employment intake clerk as well if you do want to learn more about actually moving forward with legal services. So I'll provide that. You'll get an email tomorrow morning with all that information. If Molly and Andrew, you guys have any final words, go for it, and then I'll wrap it up.
Maybe the only thing I'll add is feel free to share once you get the recording with any Bell employees that any colleagues that you have that are affected. We've been trying to do a lot more of these things because we do know that it's a difficult situation, but also that there's a lot of misinformation or a lot of misunderstanding about how people's rights operate when they've been let go from a job. And so there's like a lot of what we do with this is actually just public legal information. We want people to know that they have certain rights and entitlements because Bell has an in-house legal department that gets to inform them of all their obligations and their understanding of employment law. Employees don't, non-unionized employees don't have that same kind of access. And so as people who are often representing employees, we're doing this to try and spread the word about what rights you do have and your colleagues have. So no issue whatsoever if you want to share it with anybody else.
Yeah, absolutely.
Okay, perfect. Well, yeah, it doesn't seem like any more questions came through. So I will end it here. And thanks everybody for attending. And like I said, just keep an eye out in your email tomorrow morning with recording and some more information about moving forward. So thanks again, and hope everybody has a good night.